Please share with us a few of your most memorable learning moments. How did you approach these matters?
Yeah, so two of my most memorable moments, one involved an IT dispute and the other involved, I guess, an internal IT governance issue. The IT dispute taught me the very important lesson of making sure when you draft contracts that you completely align what we call a prime contract, so a contract between a customer of ours and Unisys. You align that contract very carefully with any subcontracts that you have. So in other words, contracts with our suppliers. It's very important to make sure especially that the intellectual property clauses are completely lined up, because if there's any misalignment, it can lead to disputes. The war story I guess I'm thinking of involved very complicated contract structure where we had a list of 4 reseller contracts between the owner of a software product and our ultimate customer. And those reseller contracts actually flowed down through Unisys. And unfortunately, as part of drafting the contract, somebody misaligned a very small part of the technical functionality description of the ultimate owner's software with what we were ultimately passing down to our end customer. Problem with that is it led to a multi-party IP litigation claim. Ended up spending the best part of a year trying to settle it with all parties involved in a way to resolve the issue. So I guess the importance there is, again, from a drafting perspective, ensuring alignment of IP terms up and down a contract chain. So the end result for us was we spent a lot of money on external lawyers, as did the other parties. Ultimately, we settled the dispute, so it didn't actually go to court, but it was a very painful learning exercise, I think, for all of us. In order to avoid something like that ever occurring, it's just really important for the drafters to take that extra care to make sure that what they're drafting in one document is absolutely a mirror of what is in another document. So another very valuable lesson that I got early on as an in-house lawyer is the importance of ensuring that there's governance around a deal team. We had a situation where we had a very large and complex customer contract which required certain terms and conditions of that contract to be flowed down into subcontracts. And we had almost fully negotiated the subcontract and were about to sign it when we realised as a group that we hadn't actually flowed down those essential terms from the customer contract into the subcontract. And if we had signed both contracts then, we would have automatically been in breach from day one of our customer contract. And so it's just the importance, again, I think, of governance around a deal team and making sure that everybody involved in the deal team come together. There's alignment again between customer contract requirements and then subcontract requirements.
What are some of the key risks that you actively help your business navigate within your industry?
So one of the key risks that we're aware of is when we respond to an RFT. It's very important, obviously, for us to make sure that the contract we offer to a client is fit for purpose. So in other words, it's important to ensure that it reflects the nature of the technology that we are offering. A lot of draft contracts we see written in a certain way. For example, it might assume that we're going to provide an on-premise solution for some software at a client's premises. This effectively means that we're going to install an application on their network at their location. However, many Unisys solutions are not delivered in that way. For example, we provide a lot of our solutions as cloud-based solutions. Often the solutions involve a large component of third-party intellectual property. And so it's not always possible to assume that the one set of IP terms in a contract will apply to all of that third-party software as well. In addition, we're involved in a lot of multi-sourcing, which means that a client will buy certain applications or services from Unisys, as well as from various other suppliers. So when you're dealing with the complexities of multi-sourcing and multiple IPR, it's just important to ensure that the terms of the contract accurately reflect the nature of the technology that's being offered. Another very common software model now is what they call SaaS, which is software as a service. The terms and conditions of a SaaS offering differ considerably from a traditional licensing model. So another key risk that we're always alert to is ensuring that we don't misrepresent the nature of what we do or breach contract terms. An example of this is often when we get a draft contract, it will have a whole set of warranties. They'll use language such as, the supplier will provide, its services and software to the best industry standards, so to speak. We're always very careful to try and ensure that where we can, we're more specific. So, for example, rather than a sort of an open or vague kind of concept, we always try and bring it back to something specific. So, for example, we might choose to refer to the ITIL model. This is the Information Technology Infrastructure Library. or we'll try and reference it to another standard, for example, an ISO standard for more certainty. Another key risk and a very timely topic now is obviously privacy and data breach. We're especially aware of this risk when we're dealing with our subcontractors, and again, alignment is the key point here. We're often required by clients to flow down to our subcontractors a whole swathe of privacy clauses. In order to make sure that the subcontractors comply, we do a number of things. So we do due diligence initially on selecting the subcontractor around their reputation and capability. We include a whole series of obligations and warranties in the contract in relation to the subcontractor around privacy compliance. And we often ask to do some sort of audit regularly on their privacy compliance. And as well, we sometimes even require annual certifications of privacy compliance from subcontractors. Further, in relation to subcontractor compliance, we always need to make sure that the subcontractors meet the requirements of the head contract around privacy. Another big topic now is offshoring. A lot of governments, both federal and state, have what they call onshore data requirements. And so if we're using a third-party subcontractor, we're very careful to make sure that they comply with those onshore data requirements. And this can often be a challenge because some of our third parties are actually cloud services providers. Cloud service providers, by their nature, can actually host data in any part of the world. So again, we take extra care to make sure that we're not breaching offshore privacy requirements when we're dealing with cloud service providers.